1 Introduction 3 Copyright 2021 Amendment 4 Part 1 Introduction to the Law, Function and Structure Introduction. This book is designed to provide an introductory overview of Canadian law. Although it will not make readers experts in any of the many specific areas of the law, it will provide an understanding of how the Canadian legal system is structured and how the law changes in response to changes in society. Why make laws? All societies in all parts of the world govern themselves according to what can be described as codes of law. As societies develop, members develop, communicate, and observe certain norms of organized and predictable behavior so that they can live together peaceably and govern their affairs efficiently. As a group of members living together grows larger, the potential for conflict and the need for organization increase. In response to these changes, the group's code of behavioral norms, or laws, increases in complexity and informality. Religious and secular laws. Not all codes of behavioral norms resemble laws as we typically recognize them. Some groups identify their rules as being part of their religion, given to them by a god or gods. Some groups live by rules that are never explicitly spoken. Consider, for example, a high school clique, membership in which depends on being cool, that is, either students are cool, understand the unspoken rules and govern themselves accordingly, or are not, haven't cracked the code of admission. In some societies, codes of religious rules actually evolve into laws for governing society, sometimes called civil laws. In other societies, a separate civil code emerges and evolves parallel to the religious code, hence the distinction between religious laws and secular laws. For many Canadians, secular laws have come to assume much greater importance than religious laws for governing behavior, but secular non-religious learning outcomes. After completing this chapter, you should be able to describe the various functions of law in society. List the stages in the life cycle of a law. Describe the origins of and differences between common law and statute law. Describe the relationship between common law and statute law. Distinguish between criminal law and civil law. Understand the distinction between substantive law and procedural law. Copyright 2021 Emmond Montgomery Publications. All rights reserved. Image with the following description. Image for page with label 4 inches. Chapter 1 Introduction 5 aspects of the parallel systems remain. For example, a modern Jewish, or Christian, or Muslim, and so on, wedding ceremony incorporates the solemnization of both religious and secular contracts, each with different provisions and implications. Leading up to the passage of Bill 27, the Family Statute Law Amendment Act, 2006, the Ontario government considered, then rejected, a proposal to apply religious law, such as Sharia, Islamic law, under the Arbitration Act, 1991. As well, most nations have deliberately separated religious and secular laws. In Canada, this separation doesn't preclude government efforts to foster individual citizens' religious freedom and doesn't mean the end of debate of religious issues in our society. The right, or not, of citizenship candidates to wear the niqab when taking the oath of Canadian citizenship was a polarizing issue in the 2015 federal election. In the same year, law societies across the country considered whether or not they would admit into legal practice the graduates of a proposed Christian law school that would require students to sign a covenant prohibiting sex outside of marriage between a man and a woman. In 2019, similar controversy accompanied the passage of Bill 21, an act respecting the laicity of the state, in Quebec when the new law banned public sector employees in positions of authority, such as teachers, judges, police, and prison guards, from wearing religious symbols while at work. The same law also requires those providing or accessing public services, such as public transit or health care in public institutions, to have their face uncovered to allow their identity to be verified. Because the requirements of Bill 21 potentially conflict with existing legal rights and freedoms, protests and legal challenges to the new law remain ongoing at the time of publication. Protesters gather to challenge Bill 21. In addition to its ban on religious symbols, including crosses, kippas, turbans, and hijabs, being worn by public sector employees, the controversial law prohibits providing or receiving public services in public institutions while wearing a face covering, such as a niqab or burqa. Of course, many codes of social rules coexist with religious and secular laws, that is, every school, every family, and even every friendship has its own code. Copyright 2021 Emond Montgomery Publications. All rights reserved. Image with the following description. Image for page with label 5 inches. Part 1 Introduction to the Law, Function and Structure. The life cycle of a law. Because of the many codes that everyone uses to govern their lives, most people are already familiar with the life cycle of rules, whether they realize it or not. For example, they know that rules are born when they are proposed by a member and adopted by the group, and that rules often evolve to accommodate changes in the group's composition or circumstances. Rules also become increasingly complex. As a group's membership expands, rules that were once either unspoken or communicated orally may become codified or formalized, that is, written down in an organized way for easier dissemination. As social circumstances change, rules go through the processes of amendment and reform whereby some rules are revised and others are replaced because they no longer meet the needs of the society. Civil or secular laws, simply, laws, from here on, follow a similar life cycle, which may include some or all of the stages shown in Figure 1.1. The introduction stage involves developing a preliminary version of the proposed law so that it can be evaluated by the lawmakers responsible for creating it. The preliminary version of the law is then debated and discussed before being adopted upon agreement by lawmakers. Once the adopted law is codified, it may become necessary to amend the law to incorporate required changes. If, on the other hand, the law is no longer required, then it is removed through the process of repeal. If changes are required, then the existing law is repealed followed by reenactment of a new version of the law that reflects the necessary changes. Codify, formalize a law or rule by incorporating it, usually in print form, into an existing or new code. Amend, change a law or rule. Repeal, terminate the application of a statute or statutory provision. Reenactment, bringing a statute or statutory provision into effect to replace a repealed law with an amended law. Figure 1.1. The life cycle of laws. Life cycle of a law. 1. Introduction. 2. Debate and discussion. 3. Adoption. 4. Codification. 5. Amendment. 6. Repeal laws are valuable to a society only insofar as they meet that society's existing needs and deal adequately with the variety of circumstances that its members. Copyright 2021, Emond Montgomery Publications. All rights reserved. Image with the following description. Image for page with label 6 inches. Chapter 1 Introduction. The 7th of May experience. When a law stops meeting the needs of the society or stops taking into account the circumstances of the society, it must evolve or be amended. This need to respond to change and to be flexible is the reason that all of our laws cannot simply be written down in one comprehensive, and lengthy, final code for everyone's reference. It is also the reason that we need lawyers to keep track of the myriad intricacies of the law, courts to settle disputes that arise over interpreting those intricacies, and a legislature to create new laws to handle emerging issues. Basically, the judicial and legislative systems are the mechanisms by which laws are formulated, designed, and interpreted in a consistent and orderly way. Sources of law. Common law and statute law. Our legal system in Canada has two sources of law: common law and statute law. Statutes are made by the federal and provincial levels of government. Laws passed by the third level of government, the municipal level, are called bylaws. Each of these levels passes laws through the life cycle described in the preceding section. The other source of law in Canada, in all provinces and territories except Quebec, 4 is common law, or case law, where the courts make law by judicial decisions. Common law. The role of the common law in our legal system is a direct result of our history as a British colony. We have inherited the common law as part of our law-making system. The common law is the body of judicial decisions made by courts in England and in Canada that establishes legal rules and principles dealing with specific issues. The common law has evolved over many years and reflects changes in society. Other legal systems, for example, those that are based on codified civil law, religion-based Islamic law, fiqh, or bilateral combinations of two legal systems, exist in other parts of the world. See Figure 1.2 for a map of world legal systems. Common law. A legal rule or a body of legal principles, established through judicial decisions, that deals with particular legal issues or subject areas. Civil law. Common law. Bilateral customary law. Fiqh. Figure 1.2 Legal systems of the world. Copyright 2021, Emond Montgomery Publications. All rights reserved. Image with the following description. Image for page with label 7 inches. 8. Part 1 Introduction to the Law, Function and Structure. The use of common law to guide judicial decision making is based on the concept of precedent. A precedent is a judicial decision on a particular legal issue that sets the law for the same or similar cases that follow. The courts in these later cases will apply the precedent and make the same or a similar decision, thereby reinforcing the legal principle of the precedent. The body of law, these cases, makes up part of the common law. The advantage of the common law system is that it provides consistency across decisions and predictability. Parties to a case will consider the decisions made in previous, similar decisions, and the parties should be able to predict what the result in their particular court case may be, barring any unforeseen developments. For example, a person charged with driving while impaired may want to challenge the manner in which the breath test was conducted. This person, with the assistance of a lawyer, can review the large body of cases that have already considered this issue to determine whether there is a valid argument to be made to the court. In the context of the civil, non-criminal court system, the same predictability promotes out-of-court settlements in many cases, which saves money for the parties and time and resources for the legal system. One advantage that the common law system has over statute law is its ability to respond to changes in society and to specific fact situations. The change, in 2003, to the common law definition of marriage is a good example of the flexibility of precedent. Previously, the common law definition of marriage prohibited people of the same sex from marrying each other. Various court decisions had supported that prohibition. However, societal views changed in the 10 to 15 years leading up to 2003. That summer, the Ontario Court of Appeal, in Halpern v. Canada, Ag. 5 considered decisions made by other courts' cases to help it decide whether the definition of marriage should be changed to include same-sex couples. The Ontario Court of Appeal decided that it would be discriminatory not to change the definition of marriage to include same-sex couples. This decision became the law in Ontario and applies to any other cases in lower courts involving this issue. The decision is binding in Ontario. Courts of appeal in other provinces heard cases regarding whether the common law definition of marriage should be changed. The Ontario Court of Appeal decision acted as a precedent, and it was persuasive to the other provincial courts of appeal. They came to the same decision, although they were not required to because the Ontario decision was not binding on them. The combined force of these decisions across Canada, and a decision from the Supreme Court of Canada, the highest court in the land, helped persuade the federal government to proceed with legislation in Parliament to change the definition officially. The Civil Marriage Act 6 came into effect in July 2005, allowing people of the same sex to marry each other. Prior to its enactment, the statute was hotly debated both within and outside Parliament, demonstrating that the courts and the legislature may not always agree on what the law should be. In fact, during his time in office 2006-2015, Prime Minister Stephen Harper made no secret of his displeasure about a number of high-profile rulings of the precedent, a court decision that influences or binds future decisions on the same issue or similar facts binding in common law, the determinative quality of a legal decision on future decisions, assuming similar facts, if it was decided in a court of superior jurisdiction, persuasive, the quality of a legal decision or precedent that influences later decisions on the same or similar legal issues. Copyright 2021, Emond Montgomery Publications. All rights reserved. Image with the following description. Image for page with label 8 inches. Chapter 1 Introduction 9 Supreme Court of Canada. These included a ruling that the country's prostitution offences were unconstitutional, 7 a rejection of mandatory minimum sentences for gun crimes, 8 a declaration of Silcoen First Nations title to a large area of land in British Columbia, 9 a ruling striking down laws prohibiting physician-assisted suicide, 10 and a ruling that the Prime Minister's appointment of Mark Naden to the Supreme Court was invalid. 11 Statute law. Governments make statute law, whether federal, provincial, or municipal, by laws. Typically, the governing party in Parliament or the provincial legislature will introduce a bill, a proposed piece of legislation, designed to address an issue or a procedure. A new bill, if proclaimed, can become a new statute, can add new provisions to an existing statute, or can create or amend a regulation made under a statute. For example, the Ontario government introduced a bill in 2013, Bill 77, the Hawkins-Gignac Act Carbon Monoxide Safety 201,312, that sought to make carbon monoxide detectors mandatory in all Ontario homes. The bill was introduced after a family of 4 from Woodstock, Ontario died as a result of a carbon monoxide leak in their home, which had no carbon monoxide detector installed. This bill was proclaimed as an amendment to an existing regulation, the Fire Code 13, and came into force on October 15, 2014. This method of changing the law may be more time-consuming than having a court create a new precedent because of the democratic process of debate and review that is an important part of our parliamentary process. However, once the statute has been passed and becomes law, there is stability and consistency in that the letter of the law has been published and is available for all to read. For example, drivers of automobiles should know that there is legislation that prohibits speeding, careless driving, disobeying a stop sign, and using handheld devices while behind the wheel. The requirements for safe driving are not up to an individual's whim, they are codified by statute and enforced accordingly. Statutes may also reflect government policy objectives. For example, all provinces and territories in Canada have human rights statutes that mandate the fair treatment of all employees and prohibit discrimination on specified grounds. In Ontario, for example, employees have a right to equal treatment in the workplace regardless of race, ancestry, place of origin, color, ethnic origin, citizenship, creed, sex, sexual orientation, gender identity, gender expression, age, record of offenses, marital status, family status, or disability. 14. Having a statute that prohibits discrimination in the workplace on the basis of a prohibited ground sends a message to all employers about the government's expectations and places them at risk of being investigated and penalized for violations. A statute is a more effective and efficient way of regulating behavior than leaving the issue to a judge to determine and monitor on a case-by-case basis. Similarly, if a statute becomes outdated, no longer reflects the government's policy objectives, if the government changes after an election, or is no longer in statute law legal provisions, in codified form, that are developed and adopted by the parliamentary and legislative process. Copyright 2021, Emond Montgomery Publications. All rights reserved. Image with the following description. Image for page with label 9 inches. Part 1 Introduction to the law, function and structure. Step with societal values, then the government may decide to repeal the statute, and the statute is no longer in force. Governments may also repeal a statute, or a part of a statute, that has been struck down by the courts. In these situations, even though the statute continues to be written down, it is a so-called zombie law that is of no force and effect. An example of this is Section 287 of the Criminal Code 15 that previously criminalized abortion. In 1988, the Supreme Court of Canada ruled in R. v. Morgentaler 16 that Section 287, then S. 251, was unconstitutional because it violated Section 7 of the Canadian Charter of Rights and Freedoms, 17, which guarantees a woman's right to security of the person. Following this landmark decision of the Supreme Court, the section of the Criminal Code criminalizing abortion remained intact even though it no longer reflected the law in Canada. It took 31 years for the federal government to repeal Section 287 of the Criminal Code when Bill C-7518 became law in 2019. Another reason statutes may be repealed by government is to gather related areas of regulation under a single new umbrella statute. This allows statutes that are related or that consider similar topics to be regulated in a consistent manner. See Box 1.1 for a discussion of statute gathering. Box 1.1 Statute gathering. Statute gathering makes it easier for people to understand and manage their legal obligations by bringing predictability and familiarity into the law. The following are two examples of initiatives that resulted in the repeal of a number of individual statutes in favor of a harmonized umbrella scheme. The Ontario Technical Standards and Safety Act. This long and detailed statute creates a harmonized system of safety standards for a wide range of equipment used in Ontario: elevators, boilers, amusement park rides, etc. When it was proclaimed in 2001, it repealed and replaced the Boilers and Pressure Vessels Act, the Amusement Devices Act, the Elevating Devices Act, the Energy Act, the Gasoline Handling Act, the Operating Engineers Act, and the Upholstered and Stuffed Articles Act. The Manitoba Regulated Health Professions Act. This act, which was passed in 2009, was designed to repeal more than 20 individual pieces of legislation regulating a wide range of professions in Manitoba: nurses, chiropractors, speech therapists, midwives, naturopaths, opticians, etc. Transition provisions were designed to manage the replacement of the various administrative schemes with one consistent scheme. Many discipline-related details under the new statute are managed through regulations. Regulations are discussed in Chapter 2. This transition for Manitoba happened very slowly, with some health professions having not made the transition by the end of 2016, a problem that reflects the reality of bringing such a wide range of self-regulating systems under a central regime. Sources: Technical Standards and Safety Act, 2000, C 2000, circa 16, the Regulated Health Professions Act, CCSMCR 117. Copyright 2021, Emmond Montgomery Publications. All rights reserved. Image with the following description. Image for page with label 10 inches. Chapter 1 Introduction 11 The relationship between common law and statute law. As we have just discussed, common law and statute law come from different sources, and each has advantages and disadvantages in terms of advancing the state of the law. The two systems do not operate independently of each other. However, the nature of the relationship could be likened to a chicken and egg dilemma: which comes first? Each influences the other, and both have the capacity to change the other. In using the same-sex marriage example, the courts redefined the common law definition of marriage, and Parliament followed suit. Yet in a future case, the courts may well look to the Civil Marriage Act to further refine this area of the law. The tension between common law and statute law comes from two competing concepts: rule of law and parliamentary supremacy. Rule of law means that no one is above the law, including governments, so if a government passes an illegal law or a statute that is contrary to its authority, the courts can strike down that law, effectively cancelling or revoking it. On the other hand, parliamentary supremacy means that Parliament makes the laws, not the courts. The tension between these two concepts is often covered by the media after controversial court decisions. However, both concepts are fundamental to our legal system and are directly inherited from the British legal system. A great deal of statute law has resulted from the government's decision to codify the case law on a particular legal issue. The government may make this decision because it believes that the common law rules are appropriate and worthy of entrenchment in statute, or because it disagrees with the common law rules that have developed on a certain legal issue and wants to ensure that changes are made. Once the legislation is passed, the common law will evolve because the courts will be called upon to interpret and apply the new statute. For example, the first time a property owner who has been charged for not having carbon monoxide detectors installed decides to fight the charge, the court will be required to interpret and to apply the new law. The decision by the court will have an impact on both the common law and the statute. The Criminal Code, for example, provides a statutory framework of rules that are considered by case law. Therefore, law enforcement students cannot simply carry around a pocket criminal code and be confident that all the law they need to know is contained in its pages. Much of the detail they will need to know to do their job properly can only be found in the common law, that is, in the rules and police practices that develop out of the criminal code through daily judicial interpretation and reinterpretation of the words used in the criminal code. For example, a number of offenses are based on possession, for example, possession of a weapon, of proceeds of crime, of child pornography, etc. To understand whether a person is guilty of an offense based on possession, law enforcement officers must be familiar with how the law defines possession. As it turns out, the definition of possession varies depending on what is possessed, considered, applied, or interpreted in a court case. Refers to statutory provisions. Copyright 2021 Emond Montgomery Publications. All rights reserved. Image with the following description. Image for page with label 11 inches. Part 1 Introduction to the Law, Function and Structure, and is quite complicated. For example, the 2014 Ontario Court of Appeal Decision in R.V. Tyrell 19 considered the relationship between willful blindness and constructive possession with respect to the issue of whether an accused whose ex-girlfriend had a loaded gun in a closet was or was not in possession of the gun despite being willfully blind to the presence of the gun. While criminal law has the criminal code as its statutory framework, many other areas of law, such as contracts and torts, are based almost completely in common law, with some specific subtopics being the subject of statutes. Contract and tort law are covered in Chapter 10. For example, landlord and tenant statutes and family law statutes, discussed in Chapters 11 and 12, demonstrate the implementation of government policy objectives and the influence of societal values in changing the common law. Criminal law versus civil law. When considering distinctions within the law, it's worthwhile to examine the difference between criminal law and non-criminal law, which is sometimes called civil law. The term, civil law, is a confusing one because it has at least three recognized usages. First, as mentioned earlier in this chapter, it can be used to describe the domestic laws governing a nation, all of those laws. Second, it can be used to distinguish the civil law system, a code-based system used in many countries around the world and also in the province of Quebec, from the common law system, a precedent-based system, used in the other Canadian provinces. The third use of civil law is to distinguish non-criminal laws and the procedures used to enforce them from criminal laws and their procedures. This third usage is the one that is discussed in this text. One of the most important differences between criminal and non-criminal civil cases is that while the parties to civil cases can be anyone, private individuals, corporations, government agencies, etc., one of the parties in every criminal case is the state, the government. Although there is such a thing as a private prosecution, the overwhelming majority of criminal prosecutions are brought by the government against a private party. Also, because criminal charges can have a serious impact on a person's freedom and/or reputation, there are special procedures incorporated into criminal proceedings that are not used for civil proceedings. To support these separate procedures, criminal trials and civil trials are decided in separate courts, at least in the first instance, at the trial level. At many places in this book, the differences between criminal laws and procedures and non-criminal civil laws and procedures are highlighted. For law enforcement officers and others who work with the law on a regular basis, understanding these distinctions poses many practical problems. For example, when a commercial transaction goes wrong because one party intentionally substitutes willful blindness, a person is willfully blind to something when they deliberately fail to turn their mind to that thing despite the fact that they could be expected to know about it. Constructive possession: a person can be found to be in possession of something, under the criminal law, when they acquiesce to another person's unlawful actual possession of the thing while they are together, even though they do not have actual physical control over the object. First instance: the first time a dispute appears before the court, at the original trial level, not the appeal level. Copyright 2021, Emond Montgomery Publications. All rights reserved. Chapter 1 Introduction 13 The wrong product for the product ordered. Is this a breach of contract? Non-criminal law. Is it the crime of fraud? Criminal law, or is it both? And is sorting out the problem the job of the police, or must one party sue the other in the civil court system? We will revisit the boundaries between criminal and civil law whenever they are pertinent to the topic being covered. Substantive law versus procedural law. Another distinction that law enforcement students should be aware of is the difference between substantive law and procedural law. Substantive law describes the type of conduct that is acceptable and unacceptable. Procedural law describes the process to be followed when there is a violation of substantive law. For example, colleges have codes of student conduct that cover cheating. Cheating, as described in its various forms in a college's code of conduct, is the substantive law. If a student violates the prohibition against cheating, there is also a prescribed process whereby members of faculty and/or administration conduct an investigation and render a decision, in which a penalty may be assessed. This process is the procedural law and includes such matters as what forms are used, what the student is expected to do, and whether the student can appeal. In criminal law, the criminal code contains both substantive law, everyone commits robbery who, and procedural law, a judge may release an appellant. Quote closing parenthesis dot. The criminal code tells us what the offenses are and what happens if an offense is committed. Both aspects of the criminal code are explored further in later chapters. In civil law, there are statutes and cases that describe the substantive aspects of civil claims, such as liability for injuries suffered in a motor vehicle accident or in a slip and fall accident on an icy sidewalk. The procedures that govern requirements, such as the documents to be served and filed and the time limits that must be met, are contained in a separate instrument. The Ontario version is called the Rules of Civil Procedure. 20 For law enforcement personnel, it is as important to respect procedural law as it is substantive law. Procedural law provides the same rules for all participants in the process to follow. Failure to follow the procedural law can be very serious for law enforcement officers, law clerks, paralegals, and other participants. Substantive law that addresses the substance or factual content of a legal issue. Procedural law that establishes the process by which substantive issues will be addressed. Copyright 2021, Emond Montgomery Publications. All rights reserved. Image with the Part 1 Introduction